Hi, my name is Ryan Brock, and today I'm going to be speaking on the Colorado Equal Pay for Equal Work Act. So we're going to start with some history of the gender pay gap. Pay gap based on gender is an age-old issue. Women have always been making less than men. The first major step in the right direction was the 1963 Equal Pay Act. Esther Peterson, appointed as the head of the Women's Bureau in the Department of Labor of the Kennedy administration, brought the act before Congress. She worked for 2 years in order to do so. President Kennedy finally signed the act on June 10, 1963. So what did this mean? This act basically called for equal pay for men and women in equal work. Despite these efforts by the Kennedy administration, the gender pay gap is still alive and well. According to the U.S. Census Bureau, in the state of Colorado, women made on average 18% less than men in 2019. So this brings us to the Colorado Equal Pay for Equal Work Act. This act was Colorado's next leap in the right direction of the gender equality in the workplace. So what is it? It prohibits using wage history as a determining factor for pay. It prohibits discrimination or retaliation against prospective employees who choose not to disclose their wage history. It prohibits employers from discriminating or retaliating against employees who are claiming their rights under this act. And it prohibits employers from discriminating or retaliating against employees for disclosing their wage rate. In addition, it requires employees to announce advancement opportunities to all employees, and it requires employers to keep record of wage history of all employees while employed and for the next 2 years after employment. So who is exempt from this? Employers who base their wages off of seniority, merit, commission, or education level of the employees are exempt from this. So what does this do to alleviate the pay gap issue? Essentially, the requirements and prohibitions of this act discourage pay discrimination by requiring employers to keep more record of wage history. This way, those who feel they are being discriminated against can take action more effectively by taking their complaint to court. Basically, employers can't pay men and women who do the same work differently. So who's covered by this? All employees are covered by this act unless your compensation rate falls under one of the exemptions mentioned. So some details about this act. Under this act, employees have the right to file a lawsuit within 2 years of the violation, and employers have the right to defend themselves in court if they believe they did not violate the act. The Colorado Department of Labor is responsible for administering a process for complaints brought to a civil court. So employee responsibilities in this matter. As an employee, the process of addressing this complaint, so basically you file a lawsuit to the civil court within 2 years of the issue. The employee is not required to take prerequisite steps like you are in some other lawsuit circumstances. And this employee will take their issue to court, and the Colorado Department of Labor is required to mediate the issue. As for employers, if a complaint is brought to the court, the employer has the opportunity to show that they did not violate the act. So basically, they can defend themselves. But if the employer is found guilty, they are required to pay the employee what they were legally required to pay, plus liquidated damages equaling the previous amount. So what does this mean for employers? As an employer, the passing of this act will require new business processes. Employers will have to be more organized. Basically, they need to keep good track of their employee wage history in case of a lawsuit. Failure to do so could result in fines and compensation paid to employees. Employers need to be more diligent. Employers need to be sure that they are keeping track of all necessary data needed in order to plead their case if it is taken to court. And employers need to remove bias based on gender. If a business has employees who are biased based on gender, this could be a liability to the company, especially those in charge of hiring and payroll. So what does this mean for small businesses? Small businesses may be more vulnerable with the passing of this act. Small businesses are less established than large businesses, so this means that they may have a harder time keeping up with the requirements that are involved in this act. In addition, flaws are much easier to identify when there are less employees. This may put small businesses at risk, but if they take the proper precautions, they can avoid repercussions. So some key points I pulled from all my research is that transparency is key. Businesses that are transparent with the wages that they're paying their employees may be less likely to be accused of breaking these laws. Communication with employees about wages is very important. Employers should be communicating how and why wages are assigned to certain employees to avoid confusion or ultimately lawsuits. Practice fair business is another key point. In the end, the best way to avoid legal issues is to follow the law. If businesses cannot find a way to close this wage gap, they need to do some serious evaluation of their business and fix the issues at hand. In the end, the wage gap is a serious issue in the United States. But if businesses and employees work together, this issue can be alleviated for a better, brighter future for all. Thank you.